You may be assuming, based off of the media coverage of the Supreme Court and Section 230, that this is one of the last videos you are going to get to watch on the internet before the Supreme Court destroys the internet as we know it, and Justice Thomas eats Google's Sergey Brin and Larry Page. So I'm attorney Scott Lesowitz, and I'm going to hopefully help you understand what the Supreme Court will and will not be ruling on, and to hopefully help you relax and chill and realize that, yes, this will be important, but the internet as we know it is not going to end, and we'll still get to watch any cat videos we may want. So the CDA is an acronym for the Communication Decency Act, which was a 1995 act passed by the United States Congress. There's two parts of Section 230 you should be aware of the CDA. One is that no provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. Basically what this means is that services like Facebook, Twitter, YouTube, etc. are not legally responsible for the content that users place on their sites. If you want to sue someone over that content, you would sue the person who posted it, not the company for just merely hosting it. And then the other important section of CDA 230 that you should be familiar with is the section that starts out, no provider or user of an interactive computer service shall be held liable on account of any action voluntarily taken in good faith to restrict access to or availability of material that the provider or users considers to be, and then it lists a bunch of bad things. So what this section essentially does is address court decisions that had disincentivized internet providers doing anything to try to clean up the content that was being generated by users, because there were cases that said, but because you took some steps to monitor what was being posted and deleted some of it, well, you were aware of that other stuff you didn't delete, and you should have deleted that too. And so the problem was that created incentive to just not monitor at all, not do anything to clean it up at all. So with that background, let's turn to the Supreme Court case that is making people think that essentially Justice Alito will be kicking Mark Zuckerberg in the crotch and destroying Facebook. So in 2015, Reynaldo Gonzalez sued Google over its alleged role in the tragic death of his daughter Noemi in the November 2015 terrorist attacks by ISIS in Paris. So the way I view this lawsuit, it essentially alleged three things. One is that Google should be held liable because it allowed for ISIS content to be available on YouTube, to have ISIS videos on YouTube. The other is that Google, through its algorithm, caused ISIS or ISIS-related videos to be recommended and promoted. And then the third is that Google shared advertising revenue with ISIS. Google shared 55% of the revenue as they would have with anybody else. The housing the videos and the failure to remove the videos by itself cannot be a basis for liability because of Section 230 immunity, and the Supreme Court is not addressing that ruling. That ruling stands. A ruling against Google on that point, I acknowledge, would be quite similar to Justice Gorsuch going up to Google CEO Sundar Pichai's mom and slapping her across the face and saying, that's for your son. So the Ninth Circuit also ruled that Section 230 of the CDA prevents Google from being sued for having in place an algorithm that caused ISIS terrorist videos to be promoted, or they use the word recommended to users. Realize that I am not saying that the Supreme Court should overturn the Ninth Circuit. I'm definitely not. I'm concerned about the unintended consequences it would have, how this might affect, cases like defamation, which might be much more common and run of the mill than a terrorism case, which obviously is very sympathetic. I also want to emphasize here that the Supreme Court is not ruling on an issue of constitutional law. The CDA is a statute. The Supreme Court is being asked to interpret that statute. If Congress doesn't like what the Supreme Court rules, Congress can step in and just clarify, amend the CDA and clarify its text to provide, greater immunity for companies like Google. However, I do also understand that Congress has become largely dysfunctional. Another aspect of this case that I've not seen really covered is that the Ninth Circuit did not rule in Google's favor across the board. The Ninth Circuit found that Section 230 of the CDA did not immunize Google from facing a lawsuit for allegedly providing material support to ISIS by sharing ad revenue with them. And this aspect of the ruling is not going to be in front of the Supreme Court. It stands. Please like and subscribe, and just everybody relax, enjoy, life will go on.